What did the appeals chamber decide regarding the Lubanga defense's appeals?
The two judgments issued today fully confirm the trial chamber's decisions on conviction and sentence issued for Mr. Lubanga. On the 14th of March 2012, the trial chamber had convicted Mr. Lubanga Dyilo of committing as co-perpetrator war crimes consisting of the enlisting and conscripting of children under the age of 15 years into the Force Patriotique pour la Libération du Congo and using them to participate actively in hostilities in the context of an armed conflict not of an international character from the 1st of September 2002 to 13 August 2003. On 10 July 2012, the trial chamber sentenced Mr. Thomas Lubanga Dyilo to a total period of 14 years of imprisonment. The time he spent in the ICC's custody will be deducted from this total sentence. Today, the appeals chamber confirmed both the conviction and the sentence. The chamber explains that the standard of review for both the verdict and sentence is differential with respect to the trial chamber's assessments of the facts and determination of the sentence. The appeals chamber only intervenes if the trial chamber's findings were unreasonable. Also of note is that with regard to age assessment and age determination of child soldiers, the appeals chamber deferred to the trial chamber's conclusion. In the views of the appeals chamber, the trial chamber's conclusions were not unreasonable. In sum, the appeals chamber rejected every ground of appeal raised by the defense and confirmed the trial chamber's verdict and decision establishing the sentence of 14 years. Judge Anita Ochaska adopted a dissenting opinion with regard to the appeal judgment rejection of Mr. Lubanga's appeal against the verdict, and Judge Sang-Hyun Song adopted a partly dissenting opinion, agreeing with the majority's decision to reject the appeals.
What is a dissenting opinion and how does it differ from a separate opinion?
In the absence of consensus, a chamber may adopt its decision by majority. A judge who does not agree with the majority can attach a dissenting or partially dissenting opinion. A dissenting opinion lays out the position of the judge but has no legal authority. A separate opinion lays out the position of a judge who, while agreeing with the majority's conclusions, adopts a different and separate reasoning, resulting in the same conclusion.
What happens next with regard to reparations?
On 7th August 2012, Trial Chamber I of the ICC decided for the first time in proceedings at the ICC on the principles that are to be applied for reparations for victims in the context of the case against Thomas Lubanga Dyilo. This decision has been appealed, and the appeals judgment on the principles of reparations is still pending and will be issued in due course. And depending on the outcome of the appeal on the principles of reparations, the reparations phase will be conducted under the authority of the ICC judges and according to the calendar that they will establish. The reparations phase may thus still take some time.
How will the sentence be implemented?
Imprisonment sentences are served in a state designated by the court from a list of states that have indicated their willingness to accept convicted persons. The country in which Mr. Lubanga will serve his sentence has not yet been determined, and it is up to the presidency of the ICC to manage this process. Until that point, Mr. Lubanga will remain in the detention center in The Hague. Mr. Lubanga has been in detention since 17th of March 2006, and under the Rome Statute, when the person has served 2/3 of the sentence, the court shall review the sentence to determine whether it should be reduced. In this case, Mr. Lubanga will have served 2/3 of his sentence on 17 July 2015. So at that point, the ICC will review the sentence.
Why do ICC trials last longer than national trials?
There are several reasons for the length of the proceedings in this case. Firstly, cases before the ICC are complex because of the nature of the crimes falling within. Okay, I will just repeat. Sorry. There are several reasons for the length of the proceedings in this case. Firstly, cases before the ICC are complex because of the nature of the crimes falling within the ICC jurisdiction. Secondly, the seat of the ICC is far removed from the scene of the crimes and the country of residence of the witnesses, and this poses logistical challenges which lengthen the proceedings. In addition, translation and interpretation are a constant feature of the ICC's work. The working languages of the ICC are English and French, and documents must be translated into a language that the accused person... There are several reasons for the length of the proceedings in this case. Firstly, cases before the ICC are complex because of the nature of the crimes falling within the ICC jurisdiction. Secondly, the seat of the ICC is far removed from the scene of the crimes and from the country of residence of the witnesses, and this poses logistical challenges which lengthen the proceedings. In addition, translation and interpretation are a constant feature of the ICC's work, and the working languages of the ICC are English and French, and documents must be translated into a language that the accused person fully understands. During the trial, simultaneous interpretation into several languages is sometimes required depending on the language used by the witnesses. In addition, the trial chamber decision, resulting in 593 pages, had to be translated into French, which took several months, before the defense could appeal it. Finally, the ICC must ensure that trials are fair and impartial, and the judges guarantee that the procedure doesn't suffer from any unjustified delay.